Okay, he got a lot of them. I just marked them up. I'm up to 9J, 9H. Yeah, he didn't come up. I just marked them. Okay. So you might have an early anything. Oh yeah, it's going to say no. And I ain't tell nobody else. I ain't you know why? Because I ain't really trying to give them their help. Fuck that shit. I deserve go. I'm fucking tired. I deserve a goddamn break. I ain't telling nobody shit. And when they see me coming in at 1, they be like, they gonna be like, you seen? I'm be like, no, honey, I'm on lunch. And I'm gonna go to lunch and then I'm gonna stay back at about 2 o'clock and then I'm gonna come out. They're like, yeah, we gotta go. When you gotta go back to court? Oh, I just called. Nikki just called me. She said we're done. And I'm sticking to it. That's my story. I'm sticking to it. Because I deserve a break up time. Wrong time another. Girl, you. I couldn't do it. I had to go to a meeting yesterday, court meeting. But, you know, sometimes time. Okay. I told my husband he could work down a couple of me. So he was like, so what that means you get off early? And I said, yeah, I can tell you what time. I know that's right. That's how I secret. I know that's right. That's how I secret. Nothing. That's okay. That's how I secret, honey. Yeah. Nothing. That's how I secret. Come on, give it me. Okay, where y'all at?
All right.
Okay, folks, good morning.
Good morning, Jerry.
And the rest of the Okay. While we are waiting, I will remind everybody to please make sure all cell phones are off. I will also remind everybody there will be no photography other than our approved still photographer and our videographer. That means no cell phone pictures, video, tablet, or any other device other than what's been approved. And gentlemen, good morning. Thank you for being here. Ladies and gentlemen, thank you for being here. We are waiting for one juror at this time. And then once she is here, we will begin. Okay? For the record? On the record?
No, it doesn't have to be on the record.
Okay.
On the record?
No, it doesn't have to be on the record.
Oh. Have to be, but should it be, or does it?
Right.
Have the, should be all.
I agree. State's defense, Mr. Medina, are present. Any issues from the state before the jury is brought down?
No, Judge.
From the defense?
Judge, 1 second, please.
Okay.
You take a look. Right there. Sorry.
There is one thing I do need to place on the record. Yesterday, the court did some further research on a defense's motion that was renewed on Tuesday morning, which was related to their experts. I had denied the motion based upon tri-state.
This will be Philip Cook, Your Honor?
Yes, in
Okay.
relationship to Mr. Cook. Thank you. I was about to say that. The court found the case State of Florida versus Michelle Hickson, which is 630 Southern 2nd 172. It's it's a Florida Supreme Court case from 1993, which is more on point than Trice's. And in that case, although the case is obviously over a decade old, in that case, the Supreme Court affirmed permitting an expert to testify to educate a jury as to battered, at that time it was called women's syndrome, but battered spouse syndrome for our purposes, and permitted the questioning of hypotheticals. While the court still stands on its previous finding that the court does believe at this time that this is a syndrome which has become part of our lexicon, the court is concerned after reviewing the court's notes that when the defense did inquire of the jurors whether they were familiar with the syndrome, more than a majority of the jurors raised their hands. And although the defense did not go through and list off every juror that raised their hand in the court's notes, there are several jurors that did raise their hands that have been seated. Based upon that, to make sure that this is a clean record, the court is going to reverse itself if, and only if, the defense can lay a proper predicate will allow Dr. Cook to testify to educate the jury as to the syndrome and answer hypotheticals. But the court will, if it becomes a relevant issue and Dr. Cook is permitted to testify, will in no way be able to opine based upon his report as to Mr. Medina and Ms. Alfonso's relationship. But hypotheticals and only hypotheticals can be asked. Okay? So that's the court's ruling. Okay? Anything that the state would like to put on the record related to that?
No, Judge. If we find any other authority, we'll submit it to the court.
Yes. The issue is that I think in the 90s this was a relatively novel issue, and perhaps the court's in a different position because I sit in this courtroom every day and we hear these terms on a constant basis, but perhaps with our jurors, a majority of them clearly was not aware, and I want to make sure it's a clean record. So if you would like to present anything else, obviously you have until such time that this defense, if they can, lay a proper predicate.
And Judge, with respect to that ruling, if I could maybe perhaps inquire in terms of laying a proper predicate.
I don't know what that will be yet, because I don't know what, if anything, this defense is going to present, but obviously before Mr. Cook or any other witnesses would be able to testify, I'll hear argument about whether or not the defense has laid an appropriate predicate.
And then, Judge, I would return to our previous question, which is, since you don't know if they're going to lay a proper predicate and they've deferred opening, will they be allowed to discuss Dr. Cook in their opening statement?
My ruling is previously announced. I think it's, as far as, refresh my recollection, it's the other doctor's name that you had made the motion about. Logan. It's going to be the same as Dr. Logan. The defense is going to make a proffer to the jury as to what they believe the evidence will show. If the evidentiary ruling comes down not in their favor, they proceed at their own peril.
Judge, it just actually occurred to me there were actually two components to the state's motion in limine on I think it was Mr. Cook or Dr. Cook, I'm not sure. The first part of our motion was actually in reference to the first part of his report, which related to his reciting of domestic violence statistics.
And that will be excluded. Statistics are irrelevant for this purpose. It's just to educate them as to the syndrome and to hypotheticals to this case. But generalized statistics will not be permitted.
Okay, thank you, Judge.
Thank you.
We have provided the defense team this morning with several additional stacks of exhibits that we've pre-marked that we may get to today or may not sure, but one set consists of photographs taken of Mr. Medina at the police station on the day of his arrest. Another set consists of a photograph taken of Mr. Medina at the Dade County Jail 8 days after his arrest. And we've also provided photos of several photos which were taken from Mr. Medina's cellular telephone, his iPhone. 6 photos in total from his iPhone, and a crime scene sketch. So we've given these for the defense to address any objections that there may be, if there are.
Okay, so defense, you're on notice that there will be, the state will be attempting to move this in, so look at those. But the jury is coming down. We'll take those.
Yes.
Is that coming through this witness?
Not quite yet, Judge. Possibly later this morning.
Okay.
Judge, I'll tell you this. There's, in the initial set of discovery, there seems to be some duplicitous pictures, which
Phones off, folks.
I'll give you an example, Judge, and I'm showing it to the government. This photograph and this photograph, they're the same thing. It's just different. In essence, I understand that there's several, the majority of these are relevant, Judge. There are just certain ones where they're panned out, they're panned in. It's showing the same thing, but from a closer angle.
And for the record, we're looking at the ones taken of Mr. Medina at the station the day of
Have they already been marked?
They've been pre-marked, yes, Judge.
So why don't you announce which ones you're speaking about?
Well, I'll say 8M and 8N, or in essence, 8M is a picture of his upper torso and his face.
8M is in Mary, 8N is in...
M is in Mary, correct, Judge. 8N is in Nancy. It's just a closer picture of his face. They both show, in essence, the same thing. Sure.
State, do you want to be heard on that?
Yes, Judge. The state's position is that the nature of the defense in this case, Mr. Medina is alleging that he acted in self-defense. We believe that the photographs taken of his body on the day of the incident from various distances are very relevant to show the nature of any injuries, or I really should say the lack of any injuries to his body. And essentially these photos were compiled to show different distances at which his torso, his back, his sides were photographed on that day. And we believe the fact that none of these photos demonstrate or show any really serious visible injuries is particularly relevant given the nature of his claims and his defenses.
Absolutely not, Judge. We're not claiming that he was injured.
Sorry.
They can show one picture, he has no injuries. I'm not going to... We're not proffering that he has any injuries.
Your Honor, Mr. Medina actually at the station the day of his arrest complained of injuries, and Miami-Dade Homicide actually summoned fire rescue for him while he was at the police station. So, and that's a part of this case. So whether the defense is claiming injuries in this trial, or Mr. Medina himself claimed injuries, I would also note that Mr. Medina was seen, or at least I should say, there are several photographs that were recovered from Mr. Medina's phone from the day of the homicide which show him taking taking photographs of himself. and he appeared to be attempting to document injuries to his left shoulder, and those are a part of what we're going to be seeking to admit later on through another witness.
Well then, Judge, they should just show pictures of his left shoulder. If there's an area of contention, let's focus on what's relevant. Let's not sit here and take 100 photographs where there's no issues. His other shoulder, his upper torso, the pictures of him without his shirt on. What is the relevance of that? To show that he has tattoos? To show the nature and the manner in which his tattoos are? They're completely irrelevant. If they're saying that there's a point of contention with a specific area, allow them to explore that specific area. But anything else is patently irrelevant, has no value whatsoever. And I'll tell you right now, the defense is not going to be making allegations of mysterious injuries other than whatever my client testified to or proffered to fire rescue and law enforcement. So I would say the majority of those photographs have no value whatsoever other than to show my client standing there without his shirt on in a manner in which an accused stands. Stand there, turn to your left, turn to your left. They look like booking photos.
And I would also argue, Judge, that in addition to the lack of injuries that's apparent, we would argue that the photographs are also documenting Mr. Medina's relative size in this case. He appears to be much thinner today, 2 years after his arrest. And these photos demonstrate that he was much bigger and heavier at the time of his arrest, which is, of course, relevant as well to his self-defense claim against his smaller wife.
Okay, at this time I will permit the state to present these photographs. The court does not find them to be duplicative. They're not of a graphic nature. They're just Mr. Medina standing there as far as it looking like it's a booking photograph. I mean, Mr. Medina turned himself into a police station. The jury has already heard that. They know that he was handcuffed and there's already been allegations that he said that handcuffed me and searched me. So my bigger concern is 9H, which is a photograph of the boxer shorts that Mr. Medina was wearing. However, in the right-hand corner, you can see Mr. Medina buttocks area. Why did this need to be done?
Oh, I didn't realize that, Judge.
Yeah, why don't you take it back and...
We'll remove that one for the moment. We'll agree.
I have no problem with those.
For the record, counsel advised me that he has no objection to the ones taken into jail 8 days after the arrest.
Are you stipulating or are you saying...
No, I'm not stipulating, Judge. I'm saying that I don't have any objections at this point to their relevance. I'm not saying that they're...
And the jury is downstairs, we'll be bringing them in.
And Judge, there's...
One moment.
It's Scott. Why are you showing this? Mr. Medina.
Okay, let me just raise an issue. I have Lewis here with sites. Pursuant to the party's request, on Tuesday, the court emailed the sites department, which is the court's IT department for the record, with the information that the state had provided to the defense and the court related to Low Point video conferencing. Apparently they have contacted Low Point video conferencing. They indicate they have no idea what we're talking about. They're indicating that they wish to bill the court system. This is a statement of defense issue. You all need to be in touch with Lewis and or Low Point Incorporated regarding the video conferencing.
Thank you, Judge. Mr. Medina will be our point of contact for that issue.
Mr. Medina?
I'm sorry, Mr. Padilla.
Okay.
Padilla.
Okay, so why don't you all talk about that?
Judge, I would like to discuss it also, so...
Well, why don't you all set up a time to do that during lunch, because our jury's outside, and I'd like to...
Judge, there's some other issues with regards to these photographs. 3 of them, I don't know. In my client's phone, there are photographs, we believe, State's Exhibit 8C, D, and E are all duplicitous, and I don't understand the relevance of 8A and 8B. I know I spoke to Mr. Dunn. He indicated 8B and 8A and 8B go to corroborate the fact that my client had spent time with his wife. I don't understand. The day before, I don't understand the relevance. That's not a point of contention.
Okay, so state 8A and 8B, these items came from Mr. Medina's phone?
Correct, Judge. They were date and time stamped on 8/7/2013. The picture of Mr. Medina and the victim sitting together was time stamped approximately 5:36 p.m. The one of him and the victim and Isabel all together at dinner was about 8:06 p.m. We submit that these are relevant to the extent that Mr. Medina told the police as a part of his statement that he and Jennifer and Isabel had spent the previous evening together at the Coconut Grove Marina, and there were indeed photographs found on his phone corroborating that. There were actually a lot more than that, but the state has simply selected those two as just representative of some of the ones that were found on his phone, which he said just goes to corroborate what he indicated he did. The photo of Miss Alfonso, I think, is obvious, speaks for itself. The photos of Mr. Medina taking pictures of himself, those were dated the date of the homicide at approximately 10:51 in the morning. This was about 6 minutes after the homicide. And these are photographs that Mr. Medina appeared to be taking of his left shoulder, and we submit that it was an attempt by him to document injuries of some sort after he had just shot and killed his wife. And we wish to submit those photos for the proposition that they, in fact, show no injuries to Mr. Medina, despite the fact that he was apparently trying to do so.
Respectfully, Judge, first of all, I don't know how they're going to authenticate these photographs.
Detective Grossman searched the phone as a part of a consent to search signed by Mr. Medina, and he will testify that these photos were recovered from Mr. Medina's iPhone upon consent.
Okay. Well, we'll take up foundationary issues after we've heard the testimony. Okay, this is what the court is going to do on these issues. The court will permit them, except the court will require that the states choose between 8A and 7Z.
Very well. Those are the two
The two
family.
family photos from allegedly the day before.
Very well.
Okay?
Judge, and finally, there's a crime scene. I got a folder labeled crime scene sketch, and it's a composite S7S. Judge, the last page is a scale of the apartment, the townhome where the incident took place. It's not the scale. There's a major issue here with regards to the setup of the kitchen. They have the kitchen in a manner in which it appears to be the size of, in essence, have the same diameter and length of the dining room. It's not the scale, and it's misleading. It's irrelevant in terms of it. Judge, I'm just going to pass it up to the court. There's markings on a stick figure, which I assume to be representative of the decedent. There's red marks. It's...
Would the court state, would you like to make a offer?
Yes, Judge. It's not claimed to be at scale, and I think the crime scene technicians will admit that it is not purporting to be at scale. It is primarily, the purpose is to give the jury an overall view of the entire scene and where various items of evidence were located, specifically the casings, the gun, and a knife found in a cabinet drawer.
Provided this to us without reason? Sketch.
Okay, the court will permit it as long as you make it very clear to the jury. I mean, it's written on the document that it's not to scale, but the court will permit it.
With the red marks there, Judge, on the stick figure showing the points of entry of the, I mean, Judge, it's, look at it.
They have to lay the foundation.
Yes, Judge.
Let's bring in the jury. Is Ms. Whitman's calling? Are you okay proceeding with that, Ms. Klein?
Respectfully, just for the record, with regards to the admission of all the photographs and all the objections that were laid, we're going to renew our previous objections today with regards to the admission of the photographs, as well as renew all our previous objections from the previous days, Judge.
Okay. Let's bring in the jury.
Please rise.
Welcome back. Good morning. Good morning.
may be seated.
Please either come in or out of the courtroom, please. Ladies and gentlemen, for the record, the state, defense, Mr. Medina, and all of our jurors are accounted for. I hope you all enjoyed your Veterans Day holiday, and that it was a safe and joyous one for you all. Ladies and gentlemen of our jury, have you continued to follow the rules and orders as they have been announced?
Yes.
Would the state like to recall Ms. Rossello Officer Rossello to the state?
Yes, Judge.
Jose, can you ask Officer Rossello? Jose, Officer Rossello, please. Ma'am, if you please come forward. You may come take a seat. Ma'am, will you please confirm for me that you are still under oath to tell the truth and nothing but the truth? I do. You may continue, Mr. Dunn.
Thank you, Your Honor. May I approach the witness?
Yes, you may.
The officer was set down.
You may sit down.
Officer Rossello, continuing where we left off on Tuesday, I'd like to show you two additional exhibits, 7A and 7B for identification. Can you recognize those?
Yes, I do.
What is the picture of those?
This is the underarm
Specifically,
of rock.
how it appeared on the video.
Yes.
Your Honor, the statement 7A and 7B at that time.
Any objection?
No.
So moved.
7B will become State Exhibit number 123. 7A will become State Exhibit number 124.
Beginning with what is 124. That's the front or the back.
This is the front of the rock, the big one.
And she did have a gunshot to the torso area?
Yes.
And 123 evidence, and that means first.
Yes.
Now, Officer, I'm going to show you two additional exhibits, which are 7C and 7D. Can you please tell us if you recognize these?
Yes.
And what do you recognize?
I recognize them by the floor, by the rock.
These additional photos you took that day. And did you very accurately take the floor rug area as you did that day?
Yes.
Your Honor, the statement was 17 and 17 evidence.
Any objection?
No objection, Judge. I would ask Mr. Dunn prior to admitting them if he can make sure the shield doesn't leave the react. I'm not objecting, but just in an exercise of
Thank
caution.
you.
Thank you.
7B will become State Exhibit number 125. 7C will become State Exhibit number 126.
Rossello, showing you what is now in evidence at number 126. Can you please explain to the ladies and gentlemen of the jury what they are seeing in that photograph?
This is the floor, and basically the victim had been removed at this time, and you're looking at a picture of all the projectile that was found underneath it.
And specifically, was it under the rug, which is pulled back in that photograph?
Judge, objection, Judge. Meeting.
Sit stand, ask open-ended questions, please.
Where exactly was the projectile?
The projectile was located exactly where that it was underneath the rock.
And for the record, what is the projectile?
Objection, Judge. This was asked and answered, yes.
Overruled.
A projectile is basically what expels from the fire and what travels out of the fire.
And states 125 in evidence. What is that, officer?
This is a closer picture of the projectile that was found.
I want to go back to something we discussed on Tuesday, specifically showing you states 7J and states X for identification. the receipt, and can you please tell me if you recognize those? How do you recognize those?
These are photographs that I took.
Sarah and I will take publication of here on that.
Yes.
That evening. Your Honor, at the time of statement, it's Act 7J evidence.
Any objection?
Judge, give me a second. No,
Yes, Judge.
You have an objection? If you have an objection, we can go sidebar.
Yes, Judge.
Let's go sidebar. Ladies and gentlemen, please excuse us a moment.
These are the two items that I collected from the residence.
Which specific two items are you referring to for the record?
This is the...
When you say this, can you read the exhibit number, please, on that stack?
I'm referring to exhibit number 1L.
Okay.
And this is basically the piece of what appeared to be formica that I collected, which is that small piece that is referred to in the picture.
And the other item?
And this is the cabinet door that was collected from the kitchen, the one that specifically had damage to it.
And did you personally collect and impound these items of evidence on the day of the investigation?
I collected them and I transported them, yes.
And could you do you recognize your markings or your signature anywhere on those items?
Yes, I do.
Okay. Could you point out where those are indicated?
These are my initials. This is my badge number, the date I collected it, the case number, where I'm routing it to, and basically what's inside the package.
And with regards to the piece of Formica, does that exhibit also contain any of your handwriting or indications of who impounded it?
Yes, it does. You can see it's basically the same information, where I'm routing it to in the lab, the case number that this item of evidence belongs to, my initials, my batch number, the date it was collected, and a brief description of what's inside.
And do these two items appear to be in the same or substantially same condition as the day that you collected them into evidence?
Yes, sir.
Okay. Now, do they appear to have been opened since you collected them into evidence?
Yes.
And can you explain why they would have been opened and resealed?
They would have been opened.
Objection, Judge, calls for speculation. Only if this officer sorry.
No speaking objections, please. Only if you know, ma'am. Do not guess or assume. Only if you have first-hand knowledge.
Let me rephrase the question. Were these items submitted to Law&Crime Lab?
Yes, sir.
And for what purpose were they submitted? Did you submit them or did you put in a request?
I wanted them to compare the piece of what I believe to be Formica to see if it actually belonged to the exterior of the cabinet that I also collected.
Okay. And in order to examine that evidence, would the lab have to open it?
Yes.
All right. Other than appearing to have been opened by the lab, are the items in the same, substantially the same condition as when you collected them?
Objection, Judge. She's You can answer.
Yes, they are.
Your Honor, at this time, the state would move these two items, which are 7Q and 1L into evidence.
Any objections?
Yes, Judge. Chain of
Can I go to the sidebar?
Your Honor, I'm sorry.
Yes, please. Yes,
Your Honor, this time, subject to link up, the state would move 7Q and 1L into evidence.
Over defense objection if it's time permitted.
One L becomes state exhibit number 129. Seven Q will become state exhibit number 130.
Detective, I'm handing you what has now been admitted into evidence as State Exhibit number 130. Would you please, I see you have your gloves and a pair of scissors. Open this exhibit up so we can show the jury, members of the jury. Your Honor, may the witness step down and
Yes.
publish the evidence.
Yes, you may.
Can you please hold this up and show each member of the jury the apparent damage that was noted on the item? Thank you all.
Mr. Dunn, could you also show the court? Thank you, ma'am.
And now, officer, I'm going to hand you what has been admitted into evidence as States 129. 129?
Yes.
Could you also please open that up and show the members of the panel? Your Honor, may the witness step down to show the jury.
She may.
Judge, this is going to be over the previous objection that we made with regards to renewing my objection.
So noted.
Thank you.
You can keep it in the box or your hand, wherever you're comfortable.
Judge, respectfully, I'm going to object to the manner in which the officer is presenting the evidence individually to the jurors. I would ask that she just publish it and allow them to handle it, as opposed to her displaying it.
Judge, it's a very small item.
Because of the nature of the item, I will direct the officer, do not have any communication. Just put your hand forward. If the jurors wish to view the item, they may. Ladies and gentlemen of the jury, in the last row, if you'd like to stand to be able to view the item. Mrs. Harris, Ms. Biano, do you need to review it? Can you just take it back to the left-hand side of the jury box and let those individuals view it? Thank you.
Can we see it too, Judge?
7O, 7N, 7M, 7L, and 7K for identification. Can you please look at those? You recognize these?
Yes.
Again, how do you recognize them?
There were photographs taken of the kitchen cabinet and stove.
And it is fairly accurate to pick how the cabinet and stove area appeared on the day of the investigation.
Yes.
Your Honor, the statement be according to the exhibits and evidence.
Yep, no objection.
So noted, that will be please been into evidence.
7O will become State Exhibit number 131. 7N will become State Exhibit number 132. 7M will become State Exhibit number 133. 7L will become State Exhibit number 134. 7K will become State Exhibit number 135. 7P will become State Exhibit number 136.
Officer, I'm going to begin with case 135 and evidence. Can you please explain to the members of the jury what you're seeing in this photograph?
This is a picture depicting the kitchen after the victim was removed, specifically markings that were placed on the stove.
What markings were placed on the stove?
Rulers that were placed on the stove. So obviously smaller rulers, if you see there'll be a close-up on it.
136 in evidence. What does that mean?
This is basically a medium view of the same picture, a lower picture of the stove.
And what was the purpose of this particular set of photographs?
These pictures were taken at the request of the defendant Pasqua.
And 134 in evidence.
This is a closer view of the side of the stove and depicting the blood that you can see on the stove.
133 in evidence.
Another picture of the same stove with the higher temperature.
132 in evidence.
Picture of the same stove.
And 131 in evidence.
A closer picture of the stove.
Now, you mentioned the detective Pasqua. Who is she?
She's part of our crime scene investigation.
And was she a part of the investigation?
Yes.
Was she on the scene processing the case? Thank you. One minute, please, Your Honor.
Madam Clerk, I need all those photographs from Tuesday.
No further questions, Your Honor.
Cross-examination,
Yes, Judge, I'm just
organizing that.
organizing.
Yeah.
Just give me a minute, Judge, so I can get my, because I have to use the items that are in evidence, and I didn't want to disturb Mr. Donohue's.
That's fine. Ladies and gentlemen of the jury, are you all doing okay? Yes. Thank you.
Judge, we just need to connect the laptop, so if you just give us a few minutes.
Ladies and gentlemen, actually, let's take a 5-minute stretch break so that we can deal with some of these matters and you don't have to sit here. With that, just remember my orders as always. It is 10:35. I'll ask you to be back at the other end of the hallway at 10:40. Thank you all for your time and consideration.
Please rise.
Oh, Mr. B, leave your pad. Yes, ladies and gentlemen, leave your pads behind. Thank you. Thanks, folks.
Okay, see the thing about it, when you go get a picture, I think when you walk up here, okay, see all these are email.
Okay.
Okay, we will be in recess.
Thank you, Judge.
Wait, one moment.
May I just also suggest, because the wires are here, maybe just warn the jurors that, I would hate for someone to trip.
And I'll make sure
Maybe just highlight to them that, we have no choice, but I just don't want anyone to fall. Thank you.
Okay, we'll be in recess until 10:40.
Okay, you can get a little flip, these are not in, but these are so...
Okay, no problem. I'll just put that aside.
Right, if you
I'll
see
put
the
it this
clip,
way.
you
No
know they're
problem.
not in, okay? So
Perfect.
all of them are like this.
If you need to use the anything, you're welcome to. Jury, okay?
And if you have a problem, you just ask them, are these in? And be like, no, they're not. So you can just leave it with them on the side.
Just brief.
Okay. So we get these things tomorrow. I might get it.
Say connect the laptop. Are you connecting something to this? Or?
No. Okay. No.
Page by page.
So that's why I did that. I figured that's what you were going to do.
When the first 3 years, I had to go. You know, 65. Yeah, I'll get you to report because that's part of the But finally, when you're here, I go to the jury section, I was like, oh yeah, let me turn this thing. The digital? Yeah, mine's good too, but I use the digital on the back of the system. I use dog.
No, it was some other stuff here. And the question before that? What was the question before that? It's going to be fine, but this question is going to come out. That's what I'm saying.
There was a brother question mark, because if you register, it's not as well. I said, hold on one second, there's a screen. I'm trying to read the question for you. Read through my mission. Get him with that. That should be there. I know my face. if I get a message, the transcript will have just up. You know what's coming back. So,